I just need you to know how this affected my kid. When she was in Louisiana, she had fake hair sewn into her head. She had braces and brackets fall off. When she came back, her whole mouth was cut up. So these, pretend like these are brackets. She had different glasses. So you got a kid with different hair put on her head, different glasses, braces taken out. They got repaired when they got back here. You want to argue about money that I spent on the trip? I don't care. I got my kid back, but the damage is priceless. You can't even put a tag on how much I've spent in regards to counseling and trying to fix her hair and having to have all the braces redone. That was on my expense list.
All right, 8:30 calendar, page 15. State versus Julie Hammer, C 338469. We do have a victim speaker present. Two.
Judge, do you want the victim? Can I bring the victim to sit here?
That's
fine
fine.
until?
We have Ms. Hammer?
She's coming right in, Judge.
Okay.
Judge, I emailed the gross misdemeanor worksheet this morning. I apologize for it being sent the day. Did the court receive it?
I have it now.
Okay. It's not very lengthy. So.
It's longer than probably 99% of the ones that I get.
I don't know if that's a good thing or bad.
It's not good or bad. He just says not very lengthy, but it's lengthier than most. All right, it's not for sentencing today. We have Ms. Hammer present, out of custody. Any reason we should not go forward today?
No, Your Honor, and for the record, Michael Castillo, my colleague, and Sophie Salcedo, on Ms. Hammer's behalf. Defense counsel has had a chance to look at the gross misdemeanor sentencing worksheet as well that got submitted to the court. I believe the only potential contention, and I'll defer to the court on how to address it, is the amount of the restitution requested. I can either address that now or save it for my sentencing argument. Whatever the court's pleasure is.
Why don't you save it for your argument?
Okay, understood.
All right. Ms. Hammer, looking at the guilty plea agreement, hereby adjudicate you guilty of 2 counts of conspiracy to commit detention, concealment, or removal of a child. It's gross misdemeanors. Looks like they had no opposition to probation. Parties agreed to a term of 364 days on each count to run consecutive to each other if they're ever imposed. State agreed that if the defendant could withdraw her plea, if the Supreme Court or Court of Appeals case number 82977 filed June 2nd of 21 results in overturning the family court orders regarding custody of the child. Right? Everybody waived any other defects.
And that was pursuant to the Alfred decision, Your Honor.
That's still in negotiation?
Yes, Your Honor.
All right. Ms. Hammer, can you give me your full legal name, please?
Julie Michelle Hammer,
How old are you, ma'am?
47,
How far did you go in school?
bachelor's degree from BYU.
You read, write, and understand English.
Yes, Your Honor.
You're charged with 2 counts of conspiracy to commit detention, concealment, or removal of a child, gross misdemeanors. With regard to those charges, how do you plead?
I plead guilty under Alfred.
Okay. Before I can accept your plea, I have to be convinced that your plea is freely and voluntarily made. Are you making your plea freely and voluntarily?
Yes, I'm sorry.
Has anyone forced you or coerced you to accept that plea?
No, Your Honor.
If I may, Your Honor. And I apologize for interrupting the court. As the court may recall, this was done after a settlement conference. She already entered her plea at the last court appearance. And that was
Did we already do that?
And that was put on the record extensively. Yes.
December 9th.
It was not on a normal calendar, so.
You're right. You're right. It's just on today for sentencing, not to take the plea. All right. Pursuant to the guilty plea agreement, I hereby adjudicate you guilty of 2 counts of conspiracy to commit detention, concealment, or removal of a child, gross misdemeanors. They have anything else that they wanted to tell me?
Judge, my argument today is briefly going to be on the additional conditions that I'm requesting that were not agreed upon by the parties. This entire case has been the result of the defendant's failure to recognize Ms. Rasmussen as a parent, despite the fact that the parties agreed to such in 2013 with the parenting order. And her Alford plea is a reflection of that continued belief. She still has yet to accept responsibility for her actions. The unfortunate harm to this entire case has been to the impact on the minor child. Her mental health has suffered severely because of the alienation caused by the defendant. This court heard testimony of that from Donald Wilburn during bad act testimony. As a result, I am going to be asking for a mental health evaluation while the defendant is on probation. I think at a minimum, this evaluation is going to be needed to ensure proper treatment is received to avoid any future issues. Additionally, because of her failure to recognize Ms. Rasmussen as a parent, I'm going to be asking or requesting that she attend and complete a co-parenting class to work on co-parenting skills. I think that would be a crucial thing for her to do. And lastly, and I stress this because it seems to have been an issue that's kind of taken place throughout the entire case, and that's the contact with the minor child. As this court is aware, there is a companion family court case that has been stayed throughout the pendency of this criminal action, which I anticipate will come back full force once she is sentenced today. There is a no contact provision in that case. That's much broader than the no contact that this court can impose, which is only reflective on the defendant. But the state's going to be asking that any contact with the minor child be at the direction of Judge Harder and family court. Going forward, they will be the court and the judge to determine what is in the best interest of the minor child. And so I would like to defer any contact through the family court. So those are the three additional conditions that I'm going to be asking for. Additionally, the restitution amount, Judge. I provided proof of the extradition fees the defendant was extradited. That cost was $2,064.30 to be paid to the state of Nevada. Additionally, Judge, under the statute for detention and concealment, subsection 7, a parent is entitled to reimbursement for the travel expenses associated with the recovery of the child. As this court is aware, the child was recovered from Tennessee, where the defendant was extradited from. And I've provided a breakdown in a spreadsheet of costs that Ms. Rasmussen incurred as a result of this case. And the number that I submitted to defense that I thought was appropriate was the travel expenses, airline, hotel, taxi, food for the travel to and from Tennessee. And that number is $2,994.11. I understand the defense is going to have some objection to those because there weren't proof, however, for some of those costs. However, Ms. Rasmussen is here today and can address some of that. I will note that the largest expense that they're objecting to was a second plane ticket that had to be purchased. Ms. Rasmussen, when the defendant was detained, she bought a round-trip ticket for herself and a one-way ticket for the minor child. When they got to the airport to come back, the defendant's sister called in a CPS report, and they were detained at the airport while an investigation went on for a period of 6-8 hours, whatever it may be. As a result, they missed their flight, and they had to buy 2 one-way tickets back the next day for them to fly back. That I don't think is disputed. There's proof in police reports that they were detained. And so the additional costs of the plane ticket and the hotel and the taxi costs for them to travel and stay overnight in Knoxville as a result of them being detained at the airport. Again, for unfounded causes. So I'll just put that out there right now. So the total restitution that I have between the two issues is $5,058.41. And the credit for time served that I do have in this case is 42 days. That was my math. Fortunately, without full motivation, I have to kind of do my own. So if there's additional days that you have, let me know.
Doesn't matter unless she does time.
Correct. And then I do have a victim speaker, which will come after at the end.
Okay. Mr. Castillo.
And thank you very much, Your Honor. And as this court's well aware, there was a settlement conference, and this was a hard, fought-out negotiation, and both sides came to what counsel would characterize as a reasonable resolution. But I do need just to pick up on a couple points that the state made. I think it's arguably improper argument for the state to offer and for Ms. Hammer to accept an Alford plea and then basically, hint around the edges that, well, I really didn't hear acceptance of responsibility, so time for a mental health evaluation. That's fundamentally unfair. And I would argue it's uncalled for in this case, and that kind of goes along with the co-parenting, class as well. She entered an Alford plea where she did not admit to a factual basis, and the court well knows what Alford is, and I would ask the court to factor that into any conditions that the court puts in here. In terms of the no contact order, obviously it's defense counsel's position that the family court proceedings, do take precedent. And I would ask the court to simply go along with any family court, directives. And as this court's also aware, Ms. Hammer does have a pending appeal with the Nevada Supreme Court, and she's hoping that she'll be successful on that appeal. With regards to the restitution, and we did talk to our counterpart for the state prior to hearing today, and I'll try not to belabor the point too much. But it's our position that with the receipts and documentation that were provided, the restitution amount, the state has $2,994.11. Our number is $1,497.29. And respectfully, I know that the state said that Ms. Murphy's here to testify today, but if they had enough time to put together a spreadsheet and provide, some receipts, then, Ms. Murphy could have provided documentation of the additional receipts, and she did not do so. So the court, in determining a restitution sum certain, has to go by what it has, and I'm happy to provide the court with the receipts that were provided to me. But generally speaking, there's not receipts for the additional plane fare, various things such as what they claim to be breakfast, lunch, and snacks, and some lodging. So our number is $1,497.29, 1497.29. Combine that with the extradition cost of $2,064.30, which we're not disputing. Our final number is $3,561.59 by my math. And as this court puts together a just decision, and you're going to hear from my client, Ms. Hammer, in a moment, and she'll expand on this, but she does want the court to know that she is absolutely dedicated to London and to her family, and she appreciates the time that this court puts into its decision. And, after a period of probation, she's looking forward, to moving on and healing as well. And I'll submit based upon that, unless the court has any questions for me.
Okay, Ms. Hammer, go ahead.
Okay, to give my statement?
Sure.
Okay.
Yes.
I just thank you for giving me an opportunity to speak. I wanted to give a special thanks for Honorable Tiara Jones for stepping in at the last moment to facilitate the settlement conference. And thanks to Your Honor for accepting our settlement agreement so that we can move forward from this case and move on to the higher court. As has been discussed already by my attorney, we all know that there is a condition in this plea agreement that allows for the validity and the legality of the orders pending before this court and every order pending before family court under which I have endured prosecution are being reviewed by our Nevada Supreme Court in Appeal 82977. I look forward to coming back before this court in the future for completion in this case, Your Honor. I just wanted to give a special thanks to my attorneys, Michael Castillo and Sophie Salcedo. It was not easy finding them. My family can attest they contacted over 40 law firms in order to find representation for me in this case. And thank you to my family and friends who have been on this journey, because this journey doesn't start here. My journey started in family court in 2012, which is over 10 years ago. And we've been before Your Honor for 3 years. And I'm also very grateful to Gonzalo and to our son, who has prayed religiously every single day for my freedom and for his sister. And it's been a very hard thing on our family to go through this. I just wanted to wrap it up with, because I am a woman of faith, and it has been faith that has guided me through this journey. It's been very challenging, and not a lot of people could stand up to the adversity, but I know that there's a greater good here, and I hope that we will get to that greater good. 1 Corinthians 15:57, but thanks be to God, he gives us victory through our Lord Jesus Christ. And that is where my faith is, and that is my rock. And I believe, Your Honor, that I will be very successful in probation. I've already been through 3 years of house arrest, and I believe that we will see completion in this case, Your Honor. Thank you so much for your time and for the judicial resources that you've extended to my case. Thank you.
Anything else?
Yeah.
All right, we do our victim speaker last. You raise your right hand and be sworn, please.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Please state and spell your name for the record.
Mary Johanna Rasmussen, nickname Murphy, Mary. Johanna Rasmussen, Rasmussen, nickname Murphy, Murphy.
Go ahead. Thank you, man.
Your Honor, I'm not exactly sure. After hearing some of these statements, I don't know what that Alfred thing is that they were talking about.
It's a way to enter a plea without admitting guilt.
Okay. So as I said, I'm not really sure where to begin. I just know that this did begin in 2012. I was looking for some timeshare with my daughter. I was told I wasn't on a birth certificate. Then I found out I was on a birth certificate, so we went into court. Gail Nathan was going to give me grandparent rights at first, but then with the brief, I won 50-50, seen as the father regardless of gender. And then this individual male was brought into it. And we've been through Judge Gail Nathan, Lisa Brown. She recused herself when Gonzalo wanted to back out. And then we got Matthew Harder. And then with some of Julie's behaviors as far as giving London medication and or taking her to various doctors, she got her legal taken away.
I'm just going to object. This seems to be outside the scope of the victim impact statement. Your Honor, it goes into the family court case above and beyond what we're pleading here today.
I'm going to give her some leeway.
Thank you. And then she couldn't get London to school or absconded with London over summer. So then another judge, while Judge Harder was trying to decide that he didn't think the recusal was fair, Judge Hopkins came in. I believe I'm saying his name right. And then I went from having weekends to the 2-5 schedule to, because she couldn't take her to school, I ended up getting London from Sundays at 3 until Friday. So Julie got Friday after school. And so, because I got a co-parent that won't co-parent with me. There have been so many orders that have been broken, and yes, she has probably wrote about 100 different motions to the Supreme Court, all come back with, can three people be on a birth certificate? And ultimately, that decision was supposed to be put in family court. So this whole thing with the Supreme Court, that's what that's all about. Then you even have her going over to Nye County, where Robert Lane has said she is abusing the judicial system and should be sanctioned. We've had 2 different parent coordinators. We've had a gal, 2 different guardian ad litems. With the parent coordinator, we were ordered to go to class. So I spent 12 weeks at UNLV going to Margaret Pickard's co-parenting class, and it was court ordered, and she was supposed to go first and never did. And I had to pay for those classes, and I went because ultimately I wanted to co-parent effectively. I have so many things written down. It just doesn't seem to matter. The issue at hand here is you have someone that is never going to follow a court order, and now there's been contact, but it can't be proven by the state. But yet I have these voice messages off of this one Snapchat where
Objection beyond scope.
Okay, Mr. Castillo, it's a victim impact statement. I'm gonna allow it.
There's been no contact order broken by Julie Hammer, and the court never got a chance to hear it, so I'm just going to play. It's very short.
And I know the court's made a ruling, but
so much every day. Because she is clinically diagnosed as bipolar. And I'm serious. Her behavior is totally unacceptable. We are choosing to.
In regards to that, my daughter will act out, and it's because of the contact that Julie is making that we can't, that unfortunately the court hasn't, or the state attorney hasn't been able to prove. Also, I'm about to show you a plethora of things that have been delivered to the house as far as communication go, and this is Julie Hammer stating to leave a backpack on the patio.
Ms. Murphy, I'm not gonna let you go through all the evidentiary arguments that it's not really before us at this point.
No problem. All right, so with the no contact order, I apologize. How the crime has affected me, or am I a kid? I can't show you the real evidence because Miss Engler has the evidence in a vault or something and couldn't produce it, and also we didn't have a jury trial. I just need to know how this affected my kid. When she was in Louisiana, she had fake hair sewn into her head. She had braces and brackets fall off. When she came back, her whole mouth was cut up. So these, pretend like these are brackets. She had different glasses. So you got a kid with different hair put on her head, different glasses, braces taken out. They got repaired when they got back here. You want to argue about money that I spent on the trip? I don't care. I got my kid back, but the damage is priceless. You can't even put a tag on how much I've spent in regards to counseling and trying to fix her hair and having to have to hold all the braces redone. That was on my expense list. You know what? I don't care. They want to squabble over a few dollars? Okay, that's fine. Lastly, I'm just showing this to you, and out of respect, I just want you to understand what this is like. One phone can't be produced because it's in with the evidence, okay? One phone. Another phone is at my attorney's office. Here's a laptop that Julie and Grandma would talk to London on, that I filmed going through the window, but I was too nervous, so it wasn't sufficient evidence. Here's another phone. Here's the phone where those messages from Snapchat, where Julie is another person, something Davison.
same
A
objection.
tablet.
I mean, we're essentially putting empty boxes and bags of pennies and just, you know.
I didn't have the brackets with me, okay? I just want you to know that these are all electronics that have showed up at my house. Okay? I paid for one telephone and a flip phone. I was able to use two phones that aren't here because there was enough evidence to give it to the phone company for them to be racing so you can get credits to get a phone. So, I mean, that's with the no contact order from Julie Hammer and then instructions on the phone, on the tape, telling her how to leave a backpack so we can drop off stuff. And even up until the 3rd, there's been contact. And yes, I guess it was by extended family, so extended family has to realize that they can't contact, but even the grandpa's like, there's no contact order and you've never been proven as a parent. And these are all just from the night of the 3rd. This is grandpa, then Remington, and then a bunch of no caller IDs, block calls, so.
Objection beyond the scope.
This is all, it's all information, ma'am, that
My daughter and I both have just been through the ringer, and there's been all the contact, all the orders that have ever been put in place since 2012 have all been broken, manipulated, and I can't get this person to co-parent. And not only since the abduction or prior to the abduction, my neighbors saw Julie Hammer trying to remove the screen from my kid's back window, cars pulling up, flashing lights into the window. And even the other night it was, we're out here, Elle, is that you? We're out here by the white Suburban. And it has affected my kid mentally. And she's now being treated for such.
Thank you, ma'am. Questions?
No questions, Your Honor, but, just so the record's clear.
You don't get to argue after the victim speaker goes, sorry.
Okay, as long as my objections are noted for the record.
You're noted. All right. This case has gone on for a long time. I know that there's been lots of motion work in front of me as it relates to allegations of conduct or contact and stuff like that. Apologize if you guys don't think that I did what I should have done. I think I followed the law. Here's what we're going to do on the case now. I'm going to follow the negotiation. Ms. Hammer, in addition to $25 administrative assessment fee, there's a $150 DNA fee if that's not previously been taken, an additional $3 DNA fee. I'm going to follow the negotiation. We'll sentence you on count 1 to 364 days in the Clark County Detention Center. Count 2, 300. There are 2 counts, right?
Yes, Judge.
Yes. Count 2, 364 days in Clark County Detention Center. We'll run them consecutive to each other. We'll suspend both of them and give you probation, not to exceed 12 months. I'm going to impose the standard conditions of probation. In addition, I'm not going to require you to do a mental health evaluation, but I am going to require you to do a co-parenting class. I think that's going to be good for you. I think it'd be good for both of you. Murphy says she's done it already. I think it'd be good for both of you. What you guys need to realize is that as much as you apparently don't like each other at this point, London is the one that's going to suffer throughout her life if you guys can't figure out how to co-parent this little girl. And
Excuse me, sir.
no, you don't get to comment again. Sorry. But hopefully the family court will determine what's in the best interest of London, because she's the one that I'm more concerned with at this point. I am going to require that you comply with all requirements of CPS and the family court. So as far as any no contact order that exists in family court, that's between you and them. But that whatever they do is going to control from this point on. I am going to require you to pay the extradition cost of $2,064.30. And I'll require you to pay the $1,497.29 in restitution to Murphy. Other than that, just make sure you report to PMP within 48 hours and do what you need to do. Be successful.
Your Honor, can you please put on record who I'm supposed to pay restitution to? Murphy is not anybody in this room. There's a
Mary Rasmussen.
Mary Rasmussen? Okay.
Also asking for the house arrest condition to be removed at this time, Your Honor.
If there's house arrest now, yeah, we'll remove the house arrest. PMP always wants you to submit your digital storage devices and passwords so they can make sure you're not causing problems on social media. That it will also potentially maybe help them to know what contact's being made. So I'm going to impose that as a condition as well. All right.
Sorry, Judge, what was that last one about contact?
What's that?
What was the last condition you said about contact?
PMP is going to want her to submit her digital storage devices and passwords.
Okay.
Okay, good luck, folks.
Thank you very much, Your Honor.
Thank you.
Thank you.